Brier. I'm a practice group chair and partner at PilieroMazza. I lead the REAs Claims and Appeals practice group within the firm. And today I'm going to be talking about how to maximize recovery. And we're going to run through various tactics for stop work, requests for equitable adjustment, and termination proposals. So thank you all for joining me this afternoon. Just to give you a little bit of background on myself, like I said, I am the chair of PilieroMazza's REA Claims and Appeals Practice Group. So I lead a team of attorneys within the firm, various associates that help me with delay claims, differing site condition disputes, terminations, and then as well as appeals under the CDA at the Board of Contract Appeals, as well as the Court of Federal Claims. And just a brief overview of the firm as a whole. So we have various practice groups outside of our government contracts group. We have a corporate group that handles M&A work. We have a corporate group. We have construction group that specializes not just in federal disputes, but commercial disputes as well. We also have a deep labor and employment bench that assists our federal contractors with any L&E specific disputes. So we really run the gamut as far as business assistance in federal contracting. All right, so first off, I'm going to walk through just the basic agenda that we're going to talk about today. We're going to start off talking about stop work orders, which are ever more prevalent given the shutdown impacts. We're also going to talk about requests for equitable adjustment tied to stop work orders. And then we're going to move into how you elevate a stop work order REA to a claim. And then we're going to cover terminations and termination settlement proposals, what those look like. Those are also ever more prevalent given the change in administration and the cuts being driven by DOGE. So we will run through at a high level some basic aspects surrounding terminations for convenience, as well as some discussion on default terminations. And then we're going to talk about just challenging stop work orders and terminations as a whole. We do have some clients that have been wanting to be more forceful about challenging those types of directives. So we'll walk through what that looks like. And then we're going to end talking about other impacts to consider, mostly talking about tariffs, tying in subcontractor quotes, and then L&E impacts associated with the rollout of various stop work orders and terminations over the last few months. Okay, so we can go to the next slide. Okay, so talking about recent impacts to federal contractors, the GovCon community knows very well that there have been a lot of stop work orders and terminations for convenience that have been issued since the change in administration, and then more so since the shutdown has been implemented. We're going to talk about best practices, certain recommendations that we've been sharing with our client base and as a whole amongst the federal contracting community. We're going to talk about the difference between an REA and a claim and where certain benefits of submitting an REA lie versus, elevating to a formal dispute under the CDA. And then just some warnings to our client base and beyond based off of certain changes that have been implemented under the Trump administration, and just some issues that we've been seeing our clients facing that, are worthy of discussing here today. And then we're going to roll into terminations for convenience, what type of notice requirements are involved there, what types of termination proposals can be submitted and what those look like. We're going to talk about how to maximize your cost recovery under those types of proposals, and then certain challenges that our clients have been facing, particularly over the past few months, just given the flood of T4C directives that have been issued, as well as stop work orders being issued under the based off of the federal shutdown. And then finally, we're going to talk about appeal rights. So what options you have to the extent you cannot get anywhere with an REA or claim with your contracting officer, and your options as far as appealing that type of dispute to the Board of Contract Appeals or to the court. We'll walk through those procedures at a really high level. I could probably talk about that for weeks. So again, this is going to be high level stuff. If there are any specific questions that you have during this presentation, please feel free to enter anything into the question box above. I do plan to address questions towards the end of the presentation. If anything is not addressed during this presentation, I will have my email at the end of the presentation available so that you can, feel free to email me or give me a call with any pointed questions. So we can go to the next slide. So what is a stop work order? So first thing I suggest to a client is they take a look at their contract to make sure that the standard stop work clause is in their contract. And the standard stop work clause is FAR 52.242-15. And basically what that clause allows for is for a contractor to submit a request for equitable adjustment within 30 days from that stop work order being lifted. A stop work order gets issued by your contracting officer, and it is what it says. They're telling you to stop work. You have to flow that information down to your subcontractor, and there is a duty to mitigate. So as soon as a stop work order gets issued, it cannot exceed 90 days. And at that end of that 90-day period, there's going to be a decision made as to whether or not the stop work order is going to be lifted and performance is going to be able to proceed, or they're going to issue, the government will issue a termination for convenience or potentially a default, dependent on the reason as to why they're issuing a stop work. So in either case, the contracting officer shall make an equitable adjustment. That is really important because shall means that they are required to do so. So one of the things that's been happening is, I've had multiple clients reach out and say, well, we've received a stop work order notice. Do you think that we are going to actually achieve cost recovery as a result of the stop work when we submit an REA once the stop work gets lifted? Under this clause, yes, you should be entitled to recovery of costs associated with the stop work order. That's standby costs, and I'll get into more of those details later. But the shall language in this clause does require a contracting officer to make a price or performance period adjustment as long as the request for that adjustment is justified. So presumably under this shutdown, if you did get a stop work order issued under 52.242-15, you should be entitled to cost and time recovery under that clause. The catch, though, is that not everyone wants to submit an REA associated with a stop work order. So you do need to understand, your customer relationship. How are you working with the government? Is it amicable? Do you feel like you could potentially annoy the contracting officer by submitting an REA? All of that relationship building, it plays into whether or not you actually want to go after those costs or not. Another new factor that is playing into whether or not these costs are going to be recoverable is the way that this administration is treating these types of stop work orders and terminations for convenience and the funding availability. We all know that DOGE has, infiltrated many of the federal agencies, which have impacted, certain cuts and cost recovery for certain contractors. I have a feeling that when this shutdown does get lifted, that there is going to be a decent amount of pushback tied to REA recovery under the stop work clause tied to the shutdown. So what I have been telling clients is that, you just want to be careful. You want to make sure that you are fully mitigating most risks as you can, as best you can, because I do think that there is going to be some pushback from contracting officers, despite this shall language that does entitle you to cost and time, where they either, take their time in responding. Typically an REA gets submitted and, you hope to hear something within 30 to 60 days from a contracting officer. I think there's going to be a slow roll in responding to stop work REAs tied to the shutdown. And I think that it's not going to be as easy as obtaining max recovery as it used to be. Just given the way that this administration is treating stop work orders and terminations for convenience and really holding tight to those types of funds. It's not automatic anymore. So it's just something to consider, if you do get a stop work order, that there is that duty to mitigate, and it is going to have an impact here. It's going to be a little bit different than the last shutdown because, again, I do think that there's going to be some pushback as far as, cutting checks for costs associated with the stop work. So we can go to the next slide. So, like I said previously, REAs under the stop work order clause are commonly due within 30 days after the lift of the stoppage. There is no required format for what this request for equitable adjustment has to look like. We, as a law firm, have certain ways that we like to format particular REAs that we do on behalf of clients. But if it's being done internally by the contractor, there is no required format. My suggestion is that you are going to be doing an REA on your own or internally for a contractor, that you make sure that you put a narrative, an explanation of facts as to how you got to where you are and why you're seeking the cost that you are so that there is justification. Another big point to make when you're submitting an REA under the stop work clause is that you actually put supporting cost information into that REA. I know that sounds extremely basic, but we have had some clients reach out and send over REAs for us to review and ask why they got rejected. And simply all they do is include a spreadsheet with numbers, but there's no underlying justification for where those numbers came from. That is absolutely necessary. So if you're, potentially going after like storage costs, storage fees, make sure that you have an invoice for those costs or proof of payment for those costs. The government is not just going to cut you a check for storage fees because you have them in a spreadsheet. You need that underlying justification. So that, although there's no required format, that is an absolute must when you are submitting an REA. Other key points when you're submitting a request for equitable adjustment under the stop work clause is that you are entitled to recovery of attorney's fees, administrative costs, and internal costs. So, if you engage an attorney to assist you in preparing your REA, or if you want to have an initial call to just get your ducks in a row, that call and the time spent by your attorney is a recoverable cost, and it should be included in your request for equitable adjustment. The same thing with your time that you spend talking to your attorney, or the time that you spend winding down operations and placing things into standby or furlough. The time that you spend doing that is a recoverable cost. I just highly suggest that you contemporaneously record the time that you're spending to do that, so that you can basically pass that timesheet on to the government and say, hey, we spent XYZ amount of time doing XYZ roles. This is the amount of hours it took us. This is our reasonable rate for that time, and that's why we're seeking this cost recovery. And it's the same thing for internal costs. So if your HR team, is talking with personnel and placing them on furlough or trying to figure out the benefits that they may need to pay while they're on standby, that time is a recoverable cost. It's directly tied to the stop work directive. So just making sure that you're tracking on that time, because it is something that is compensable. There is no required deadline for the government to respond to these REAs. So that kind of feeds into my warning previously, that I do think that if we are submitting REAs tied to the shutdown, that there is probably going to be some lag in responsiveness, not just because of the way the administration is treating these, but because of the mass and bulk REAs that are going to be received given the length of the shutdown and the widespread impact. So because there's no required deadline for the government to respond, if this is a cost that you cannot carry for a significant amount of time, you need to think that through. And we'll talk about how we potentially elevate these types of issues to get them moving. But it's a reminder that REAs do not have a required deadline for the government to respond. So it's something that you have to keep in mind when you are submitting an REA, that you're not gonna get a response within 10 days. That's unlikely. Typically, again, we're talking 30 to 60 days, but I believe that it's gonna take longer than that given the circumstances currently. So we can go to the next slide. So best practices on stop work orders. So one of the things I've been coaching clients on really over the last few weeks especially is providing notice to your contracting officer that you do intend to file an REA. If the stop work directive is having a significant impact on your personnel, for instance, you're having to place 30 plus people in furlough status. So you recognize that there's going to be a significant cost associated with the stop work directive. Start having that conversation now. Even if the contracting officer is furloughed as well and there's no one there to take an email, create that record. It's so important to create a written record so that you are putting the opposing party on appropriate notice of the impact. The last thing you want is the contracting officer coming back to you months later saying, well, you never told us that this was happening. Like, how are we expected to have these funds available to pay you for this stop work if we had no idea for the last 3 months that you had placed this many people on furlough status? Start having those conversations early. The same thing with a time impact. If you feel like you've gotten a stop work order and your POP maybe expires, in February, say shutdown gets lifted in December, do you want that POP extended for the amount of time that your shutdown was for the shutdown in place? Start having those conversations with your CEO about that early. Again, even if they're not there, shoot an email. You're creating a written record of that request. It's really important to start having those open lines of communication. So that's what we've been suggesting to clients. We've always been suggesting that, but even more so in the atmosphere that we're in right now. opening up those lines of communication is really important. Other first big best practice, mitigate, mitigate, mitigate. So there is a duty to mitigate. If you are taking no action to do so, the government is not just going to write you a blank check to keep people on your bench. So really important that you're taking the appropriate steps to reduce costs, to tell your subcontractors that they need to be doing that as well, and recording the proof of mitigation. So one of the, an example is, we've had clients that have significant facility costs tied to a stop work or even a termination for convenience. You cannot just charge the government for those facility costs while you're on standby or, as a result of the termination for convenience, say you're tied into some 12-month lease agreement and you get terminated at month 3. You actually have to make the effort to communicate with your landlord to see if there's any way you can minimize that cost, whether it's a reduction in lease cost, if they can find a replacement tenant or a temporary tenant, anything like that. It's something that you need to actively engage so that you can demonstrate to the government, even if it's fruitless, right, that, hey, we made that call to the landlord and we tried to reduce this liability for the government and it's just not something that could be done. That evidence of action and attempt to mitigate is really important, and the government takes that strongly into account. So again, that's another best practice. And then documenting your efforts in implementing the stop work. This ties back into recovery of administrative costs. So if you're able to, if you have your HR team documenting the time that they're spending in demobilizing, that is all stuff that you need to be doing from the jump. As soon as you get that stop work directive, making sure that things are being done in writing. If you're having conversations and calls about things, that you're preparing meeting minutes, daily reports, something to that effect, so that when you are seeking costs associated, the government is tracking on that. You're not just saying, well, hey, we need $2,000 for the discussions we had with HR over all of these directives. They want to see evidentiary proof. So documenting is extremely important. Consider filing a claim in lieu of an REA. So this feeds into that timeliness piece. So, when the change in administration happened, we saw a huge rollout of terminations for convenience and stop work orders, across the board. I had some clients coming to me with 11 stop work orders or terminations all at one time. That's a significant impact on your bottom line. So the fact that REAs don't have a deadline to respond, it is a significant impact in the sense that certain contractors can't carry that cost for a lengthy amount of time. So what I've been telling clients is that you create an internal company deadline, right? So, hey, the stop work or termination it's costing us, $100,000 a week or something to that effect. We can only carry that for 2 months. If that's the case, let the REA sit out there for 2 months. Once you hit that 2-month internal deadline, that is when you need to consider elevating it to a claim. And the reason being is when you elevate your REA to a certified claim under the Contract Disputes Act of your contract, once that claim gets submitted, the government is actually on a regulatory clock, unlike an REA. They have 60 days to issue a final decision in response to a claim. So it gets the ball rolling, it gets a formal clock started. You're more likely to get a decision once you elevate to a claim. So again, really important to understand how long you can carry those costs associated with a stop work or termination directive. And if you can't carry it any longer, that is the juncture as to when you would want to elevate that to a claim. The other thing that we've been telling clients is reserving your rights to challenge the underlying directive. This doesn't necessarily relate entirely to the shutdown implications, but more so to DOGE. So again, when there was the change in administration, we saw an uptick in terminations for convenience and stop work order directives. A lot of that was being challenged in court. And there were, various outcomes as related to, certain cuts being made to various agencies. What we are telling clients, and I think it still remains impactful, is that when you receive a termination for convenience, maybe tied to DOGE in particular, that you reserve your rights to challenge that directive. So the way that we've been phrasing that is, contracting officer issues you a stop work order tied to DOGE. You respond and say, we are in receipt of the stop work order and we will proceed accordingly. However, we reserve our right to challenge this underlying directive based off of X case. Because again, a lot of these challenges to certain cuts are still tied up in the courts. So it's really important to understand active litigation at various courts, the courts of federal claims, various district courts, so that you can preserve your rights to challenge based off of the outcomes of those cases. Again, a lot of them are, right now at the appellate level or even at the Supreme Court. So issuing that underlying reservation of rights, really important thing. We've had a lot of clients doing it, just so you have a written record to the extent there's a favorable outcome in the higher courts. So we can go to the next slide. So when I talk about considering elevating your REA to a claim under the CDA, time is not the only impact. These are some other factors to consider when you're deciding whether to submit an REA or to elevate the issue or dispute to a claim. And one of the first items being whether there's plenty of time left on the contract. So we have clients approach us and say, well, hey, we're in a dispute over a differing site condition. We have to provide notice right away. We want to file an REA and get this resolved. That's a good time to submit an REA because it's early on performance. The notice requirement is there. You hopefully still have an amicable relationship with the contracting officer. And there's a lot of time left to try to negotiate through some type of adjustment. Again, I would lean on recommending that you submit an REA under those circumstances. Another reason why you may want to go the REA route is if the issues aren't really contentious yet, or maybe the customer has signaled an openness or willingness to negotiate a type of adjustment tied to some type of government-driven change order, as an example. That is when an REA works wonders. It's a formal submission, but it's still seen as a negotiation. The parties are not in an adversarial stance. Another reason why you might want to go the REA route is that you can include your legal expenses and administrative time spent preparing the REA. If you're in a complicated construction dispute over like a time impact analysis, having legal and potentially a construction consultant weigh in, those costs can be included in your REA. So important to take that into consideration. And that may be a good avenue for you to recover those costs while you're negotiating through the REA. When you want to, step outside of the REA process and elevate to a claim is when there's really little time left on the contract. So you're at the tail end of completion. You've maybe potentially tried to already negotiate this with the contracting officer in some form or fashion, and there's been a lot of pushback. The issues are really controversial, or the relationship with the customer is really bad. Those are instances where a claim is your friend. And that is when I would suggest or recommend that you elevate the issues to a claim so that you can get a more formal decision from the contracting officer, and they're on the clock to at least respond. Another thing is, right, like I said before, if you can't wait indefinitely for the government response, a claim is the way to go. Because of that regulatory clock that they are put under the CDA, the 60-day window is really there as a benefit to a contractor. So again, elevating to a claim, considering the type of relationship that you have, the time left on the contract, and whether or not you can carry certain costs associated with the dispute. One important piece is that on a claim, you cannot recover legal or administrative fees spent in preparing the claim. So just something to keep in mind that if, say, you submit an REA, you have some legal associated with that, those legal costs can be included in your REA. They can be rolled into the claim, but the time spent on preparing the claim itself cannot be, legal fees cannot be recovered associated with that. So just something to keep in mind. We can go to the next slide. So some warnings, just like these are practical points that we've been seeing since the change in administration. And a lot of it is because when DOGE came in early on in the process, and it's still, unfortunately, still happening, where we're seeing a lot of these directives being issued by contracting officers, and they're not going under legal review, which is a huge problem. Previously, that was a thing. It's not so much a thing anymore. And so there's been a lot of errors in certain stop work order directives and terminations for convenience that have been issued. So the big warning is, if you have a commercial item contract and you are getting a stop work order directive, it's citing to 52.242-15, it's likely improper. And the reason why I'm saying that is that commercial items contracts, in order to make a change to your performance, it has to be bilateral. So you would want to take a look at 52.212-4 and see what your changes clause says, because again, it's typically a bilateral requirement to make a change. Stop work clauses aren't typically in commercial items contracts. So second thing you want to do is take a look, is that clause in there? Again, it's unlikely to be in there. So any stop work order directive that you're getting in accordance with that clause is likely inaccurate or improper. So there have been instances where we had clients getting stop work orders under that clause who had commercial items contracts. We pushed back and then we were able to negotiate adding in that clause for some consideration. So it does give you some leverage. If the government is trying to stop work to either assess funding or understand, the DOGE implications, there is some pushback there and some leverage that you can take into account, something to think through, and just understanding the actual clauses that are in your contract, because that has been done in error. Another thing that we're seeing is stop work orders being issued under the suspension of work clause, 52.242-14. It's important to understand the distinction between the suspension of work clause and the stop work order clause. The reason being is because under -15, REAs are automatic. Like I said, that shall language is automatic. So the contracting officer shall make an adjustment to cost and time associated with the stop work under -15. Under -14, the suspension of work clause, it is not an automatic recovery. And the reason being is that the clause basically says that if the government has unreasonably suspended your contract, and that language is really important to understand, because the government could say, well, we're under a shutdown and we issued a suspension of work, but it wasn't for an unreasonable period of time. Therefore, we're not going to allow for an adjustment here. -14 gives the government an out. -15 technically does not. So if they are issuing you a stop work order under the suspension of work clause, I would go back to your contracting officer and say, can you reissue this under -15? Both clauses are in our contract. This is actually a stop work directive. It's not a suspension of work. And therefore you should reissue it. So again, pushing back there is important if you can do it, and understanding the distinction between those clauses is really important as well. Another thing that we were seeing since the change in administration is stop work orders not being issued by contracting officers. This is a huge problem, because if you are operating under this assumption that you are, to stop work or cease performance, and your CEO is not a part of that conversation, you're working at or stopping work at risk and could potentially face a default. So if you're getting stop work orders, if you're getting terminations, make sure that those are coming from your contracting officer. If they are not, follow up with your contracting officer to confirm in writing that this is a directive coming from them, so that you don't run into any issues, down the line as far as performance or non-performance. Another thing that we were seeing early on, and this has kind of died down a bit, is when all of the DEI restrictions came out early on in the change in administration. And what some contracting officers were doing was that they were asking contracting officers were asking contractors to certify that they had removed DEI related programs in exchange for a lift of a stop work. And some of our clients were just signing those certifications to get performance running again without actually doing an evaluation of their employee handbook or internal policies. And that creates a huge false claims risk. So if that is still happening, or if you're getting any sense of, kind of a tit for tat as far as certifying to removal of DEI in exchange for a stop work order lift or a termination lift or anything to that effect, make sure that you reach out to an L&E attorney. Our L&E group is doing a lot of these assessments. So really important that you're not just blanketly signing that certification without doing that internal assessment to make sure your policies are aligned with that, what you're actually certifying to. So we can go to the next slide. Okay, so additional warnings. Another thing that we're seeing once the stop work orders are being lifted, or once we're engaging in negotiations over a termination for convenience proposal, is that the government is always wanting to include waiver language in contract modifications, which releases them from any liability for any action or inaction. So this is a practical example. When the shutdown lifts, there's going to be a lot of contracting officer pressure to issue modifications to extend performance, or maybe to negotiate through costs. Make sure that if you are signing a modification tied to that, if it's favorable, that even if there's release language in there, that it is it has to be limited to what you are negotiating, that it's not a blanket waiver of claims, because you may have a claim that's completely outside of your shutdown adjustment request, and you could be fully releasing that claim by signing a modification tied to, again, adjustments tied to the shutdown. So I always remind clients, just because the government put waiver and release language in a modification doesn't mean you have to sign it. There's language that can be stricken. I've drafted many release clauses that are, again, specific to the adjustment that's being sought, and allow you to reserve your rights to seek additional request for equitable adjustment or certified claims. So don't feel like you're boxed in when you get a modification with certain waiver language. There is pushback. You're in an arm length negotiation with the government. Push back if you can. So like I said, try to get the government to remove the waiver release or add your own language to the release. And we draft, like I said, draft that language all the time if you have questions. Just something to keep in mind, that it's not an automatic thing. You can push back. So we can go to the next slide. Okay, so we're going to move a bit away from the stop work order process and move into terminations for convenience. So what is a termination for convenience? So every federal contract has a termination for convenience clause. The clause is a little bit different if you have a commercial items contract, so just something to keep in mind. But all in all, it's pretty much the same, where it's giving the government discretion to terminate a prime contract for convenience. It can, like I said, be initiated for generally any reason. The nature of the settlement proposal and your entitlement to recover very much depends on the type of contract that you are operating under. And we'll talk about this in a bit, but you may need to convert the settlement proposal to a claim if you reach an impasse with the government in negotiating or resolving your settlement proposal. So we can go to the next slide. So you've received a termination notice, now what? So my first suggestion is that you take a look at FAR 49.104. This provides a list of the duties a prime contractor has to partake in once they receive a notice of termination. I'm not going to read everyone here, but ultimately you would have to stop work immediately on the terminated portion of the contract and stop placing subcontracts thereunder. You also have to notify your subcontractors immediately that they are being terminated for convenience. Another big practice point, making sure that if your contract has a termination for convenience clause in it, that you similarly have flowed that down to your subs so that you have the ability to terminate really for any reason as well if you are prime. And then you also want to immediately advise the terminating contracting officer of any special circumstances that may preclude your stoppage of work. Like I said, opening lines of communication with your CO is extremely important in both stop work and termination context. So making sure that they are well aware of any impacts or liabilities that are continuing to accrue once that termination notice gets issued. And then another big point is disposing of termination inventory, making sure that you have appropriate directions from your termination contracting officer as to what that should look like. So these are all, again, in 49.104. Take a look at that so that you understand what is required of you. And typically, if you are receiving a termination notice, these items are carried into that notice as well, so that the contractor, once they receive it, they actually have a full understanding of what is required of them upon receipt of that notice. So we can go to the next slide. So when I said previously that a proposal is very much tied to the type of contract that you have, here are the main 4 termination for convenience clauses. So if you have a firm fixed price contract, typically 52.249-2 is going to be in your contract. And there's certain forms that are required as part of a proposal under 249-2. Typically standard form 1436. Again, this is a little bit more nuanced, and it's something I am happy to talk through outside of this presentation, but there are certain forms that are required as part of these proposals, and it also is dependent on the type of contract that you have. So 249-6 is the typical termination for convenience clause that's in a cost reimbursable time and material contract. 249-4 is the typical short form termination for convenience clause under services contracts. And then 52.212-4L is the termination for convenience clause that is typical of commercial items terminations. Commercial items terminations do not have standard forms that are required to be submitted, but it's its own special animal as far as what proposals look like under commercial items, and I will talk about that in a little bit. So what type of recourse do you have once you get a termination for convenience from the federal government? So there's a litany of costs that you can go after under the termination for convenience clause. This list that is up here in the presentation is not exhaustive, but it mostly covers your direct costs, settlement expenses, so you are able to recover legal fees associated with assistance on a termination proposal. You're also able to recover accounting and clerical time, similar to the stop work order. If you get a termination for convenience, what I suggest to clients is they open up a separate cost code so that they can record the time that they're spending on winding down that particular contract, working with HR, placing people on different contracts. All that time is a recoverable cost as long as you're contemporaneously recording the time expended. And then subcontractor claims can be passed through, making sure that, like I said, that termination for convenience clause is flowed down to your subs, and that they also similarly have the right, as long as the costs are justified, to pass through those claims to the government. And then indirect costs. So markup like G&A and overhead, that can also be included as long as you're not double dipping in any fashion. And then unpaid invoices, right? So if, say, you get terminated in the middle of the month, you've been performing 15 out of the 30 days and you haven't gotten paid for that last month of performance, invoices can also be rolled up into that proposal for negotiation. So just keep that in mind, that those costs are also a recoverable cost outside of just termination specific costs. Claim costs do have to be allowable, allocable, and reasonable. Check out FAR Part 31. That's going to run you through what that means, but just making sure that you can justify and support those costs and that they're tied to your particular contract is very important. Another reminder is that you do need to mitigate damages. This feeds into my example previously on lease facility costs. Making those calls to your landlord to see if you can negotiate out of a 12-month lease, say you got terminated at month 6. Same thing for equipment if on product return. Can you resell certain products? Can you reuse equipment on different contracts? Can you place personnel on a different contract that once it gets terminated, can you repurpose them? So really important to understand the duty to mitigate and that you can't duplicate recovery. So again, making sure that there's no overlap or double dipping in any form or fashion, because the government does analyze these proposals very closely and they sometimes will audit them. So if you're submitting a termination for convenience proposal that's over $1 million, typically that goes under audit with the OIG within the specific agency. So really important that your costs are justified and supportable. That kind of feeds into why you may want your accounting team to take a closer look at things. But again, the support has to be there. Tying back to what I said previously, we cannot just submit a spreadsheet of costs to the government and think that they're going to pay that. You need invoices, you need quotes, you need proof of agreement. So another example is if you're trying to go after those lease facility costs, the government's going to want to see your lease agreement to understand what those terms and conditions are and why you potentially could not negotiate out of it. So all that underlying information is extremely important. What we do when we are preparing termination proposals on behalf of a client, we pretty much prepare like a package of information that includes the underlying evidence to support certain cost categories, and then legal argument as to why certain cost categories are recoverable under the FAR, under the termination for convenience clause, and FAR Part 31, as to why these would be allowable, allocable, and reasonable costs. So we can go to the next slide. So can you challenge these stop works and terminations for convenience? So when a lot of these terminations for convenience were being issued significantly as a result of the change in administration, right? DOGE was coming in, a lot of these were being rolled out. We had a ton of clients reaching out to me specifically saying, well, we want to fight this. We want to litigate. This termination for convenience is unlawful. It's being done in bad faith. Like, what can we do? And the problem with the termination for convenience in a federal contract is that a ton of discretion is afforded to the government to get out of a contract. They really can have any reason to do so. And it's a kind of a blanket ability for them to, again, get out of it. So how do you challenge that? The only way that you can get out of a termination for convenience is to demonstrate that it was being done in bad faith or a clear abuse of discretion. So this is what I like to call kind of smoking gun evidence, right? Where you have an email from a contracting officer saying that they hate you and they just want you off of this contract and there's no other reason why they're kicking you out. That is kind of what you would need to demonstrate bad faith in this type of circumstance. If it's policy driven in any way, that's not really bad faith, at least from the court and the board's perspective. And the other big point to make is that even if you demonstrate bad faith when you're challenging a termination for convenience directive, you are not entitled to your contract back. So when I had clients reaching out, they're like, we want our contract back. Like we can't get, we're going to have to lay off, 50 people. What do we do? You're not guaranteed your contract back, even if you can demonstrate bad faith. What you are entitled to is your loss costs of performance for the POP. So say you get terminated for convenience month 6 of a 12-month POP, and you demonstrate bad faith on a termination for convenience, you would get those additional 6 months, and that's it. You are not entitled to your contract back. So the relief afforded on a bad faith termination for convenience is unfortunately quite limited. And it's important that contractors understand that, because sometimes the juice is not worth the squeeze. I mean, we have been happy to litigate various disputes. We have been pushing back significantly on, for instance, grant terminations for convenience, where we believe that they were driven by bad faith. And we've seen really positive outcomes as a result of that. But there's no guarantee that you're going to get your contract back. It could happen, but the FAR does not require that, and the boards and the courts do not require that either. So it's just something to keep in mind. If you do get a termination for convenience, it is quite challenging to actually get your contract back as a result of demonstrating bad faith. So we can go to the next slide. So really the better practice in challenging a termination for convenience, like I said before, is reserving your right to challenge the high level determination while stopping work and processing the termination. So instead of, saying, well, this is done in bad faith, we're not stopping work, that creates a huge risk for your company. What the better move is to reserve your rights to challenge based off of, hopefully a dispute tied up in litigation right now, and to the extent that there's a favorable outcome, that you could then revert back to your reservation of rights and either try to get your contract back or try to recover some form of damages. That way you're aligning yourself to the directive while also maintaining your rights under the contract. Really important that we continue to keep an eye on federal court decisions and impacts of any injunctions. This was really busy, in the first few months, but there's still a lot of litigation tied up there as far as challenging a lot of the decisions being made by the Trump administration as it pertains to federal contracting. So keeping an eye on that. We're doing that as well. We put out a weekly report with updates on the impacts of these cases. So again, really important to just keep an eye on it. And then the other thing I've been telling clients is contact your congressperson. They want to hear from you. If these terminations are significantly impacting your bottom line, let them know that. That's your lifeline to hopefully some change. So making sure that you're opening a dialogue with your representatives is really important. And then if internally you can't no longer carry a cost associated with a stop work order REA or a termination proposal, once you reach an impasse there, the next step is to file a certified claim under the CDA. So really important to understand when you're ready to do that and elevating that dispute, so then you can put the government on a 60-day clock to respond or issue some final decision that allows you to potentially appeal that to the Board of Contract Appeals or the Court of Federal Claims. So we can go to the next slide. So appeal rights. So what happens if you submit a stop work claim and it gets denied, or you submit a termination for convenience settlement claim and that gets denied? What do you do then? You have the right to appeal that denial to the Board of Contract Appeals or the Court of Federal Claims. Some agencies have their own Board of Contract Appeals separate and apart from the Armed Services Board of Contract Appeals and the Civilian Board of Contract Appeals, and that's the Postal Service and the FAA. But typically, if you're in the federal space, you're operating within the Armed Services Board or the Civilian Board, and Armed Services covers DoD-based contracts, Civilian Board covers civilian-based contracts. So those are really the two boards that you would be operating within. And then the Court of Federal Claims is also an option. So what would happen is if your claim gets denied, you're going to get a notice of denial from the contracting officer, and they should be laying out your appeal rights. And you have 90 days to appeal that denial to the Board of Contract Appeals, or you have 12 months to appeal to the Court of Federal Claims. And so, I constantly have clients asking me, well, which way should we go? Which forum should we pick? And it's really important to understand that once you pick a forum, you are stuck in that forum. And what I typically recommend to clients is that we go to the Board of Contract Appeals. And there's a few reasons why, and one of them being that Board of Contract Appeal judges, they are administrative law judges, but most of them are former government contracts attorneys. So they know the ins and outs of the FAR. They understand what these contracts look like, and it's their bread and butter, and they're best equipped to handle these types of disputes. The Court of Federal Claims is obviously well established, but not all the judges have government contracts experience. Some of them specialize in patent law, for instance, or intellectual property. So not all of the judges at COFC have a foundational understanding of government contracts, which again is a hamper. So again, I typically recommend going to the board. Another reason is that it typically is a little less formal, and the costs, because of that, the costs are a little bit lower. I mean, it's still expensive to go to either forum, but the Board of Contract Appeals typically can be less expensive. And the Board of Contract Appeals also offers alternative dispute resolution off-ramps earlier on in the process. Typically, if we take an appeal to COFC, the Department of Justice will represent the agency at COFC, and they're less inclined to discuss settlement before discovery runs its course. Whereas if you go to the Board of Contract Appeals, agency attorneys are more inclined to discuss settlement or potential mediation earlier on in the process. So that's another added benefit of going to the board. Both decisions from either the Board of Contract Appeals or from COFC can be further appealed to the U.S. Court of Appeals for the Federal Circuit. So say you don't win at the Board of Contract Appeals or COFC, there isn't another level of dispute where you can take that dispute, and that is to the Court of Appeals for the Federal Circuit. And like I said previously, as far as alternative dispute resolution options, they are available at both forums, at both BCAs and COFC. Like I said earlier, though, there's a more likelihood that you're able to engage in those earlier alternative dispute processes at the board versus at COFC. But one thing to keep in mind is that it is voluntary, so you do need opposing counsel, so the agency, to be on board with engaging in alternative dispute resolution, and whether that's mediation, binding mediation, or informal avenues. The government obviously has to be in line and inclined to engage in those off-ramps before or in lieu of litigation. So just something to keep in mind. And another big point to make is that when you do appeal to the Board of Contract Appeals or to the Court of Federal Claims, it does open the ability to collect damages from the judgment fund. And the reason why it's worth mentioning is because we've had a lot of stop work REAs and a lot of termination for convenience disputes where the government's like, we just don't have the money to pay this. DOJ has just slashed a lot of stuff. The funds are just not there to make payment. But if you appeal it, it opens us up to the judgment fund and for us to obtain and retrieve damages from the judgment fund. So there is an avenue there that if you find yourself in a situation with the government where their hands are tied as far as payment, appealing it as a dispute under the CDA to the Board of Contract Appeals or to COFC does open up that ability for payment. So just, again, something to keep in mind that is available to you if necessary. So we can go to the next slide. So this is the last slide, just talking about other impacts. I thought it was worth mentioning just some of these points. Tariffs are having a huge impact on our client base. We're fielding calls on tariffs on a weekly, daily basis. Making sure that your contract has these particular clauses is important. We put out a bunch of client alerts on this as well, so feel free to check our website on these issues. But 52.229-3 does entitle you to recovery under the REA process for after imposed federal, state, and local taxes. But it is really important that you understand when I say after imposed, that these are not taxes that could have been known or should have been known at the time of contract award or the time of bidding. The timing of these tariffs and impacts is extremely important. The foreign tax clause for this is 52.229-6. So if you're operating in the international space, if you have contracts overseas, this is the clause that you would use for, again, like Middle Eastern imposed taxes, for instance. And then seeing if your contract has an economic price adjustment clause, and if it doesn't, maybe opening up a conversation with the contracting officer to see if you could negotiate that into your contract. For instance, if there is like a particular product or service that is like tied to a particular market rate, getting that EPA clause in there to fluctuate based off of the adjustment in the market rate could be of a benefit to you. So having that conversation with the contracting officer, given the significant impacts that tariffs have been having, is worthwhile. I mean, you don't get what you don't ask for, right? So starting those negotiations is important if you can have those conversations with your CO about potentially implementing some form of EPA clause. Another practice point, locking in subcontractor quotes. As we know, the supply chain impact or disruptions caused by these tariffs has been significant. So we've had clients that have not locked in subcontractor quotes and now are dealing with significant increases. So just understanding your supply chain distribution line, understanding when is a good time to lock in certain quotes at leading up to bids or even post bid. All of that's really important to help your bottom line when you are feeling the impacts of these tariffs. Unpaid invoices, just making sure that you are putting pressure on getting things paid. If your unpaid invoices are lingering, you have the right to file a claim for non-payment, and you then are entitled to CDA interest accruing on top of that. So not just Prompt Payment Act interest, but you can also go after CDA related interest. So we've had clients reach out and say, we haven't gotten paid for 6 months. Like, what can we do? File a claim. Get that claim out the door, put pressure on the agency to pay you, given the additional accrual of interest. The other thing that we're seeing are these just unforeseen delays due to supply chain disruptions, which I talked about, even ever more so to lock in quotes and really gauging those delays and impacts as you bid on future work. And then doing an internal evaluation of your employment handbook and policy changes to making sure that they're aligning with the overhaul of the FAR and changes to DEI related policies so that you're operating in accordance with the changes from this administration. Also a really important practice point. So that is it for today as far as my presentation goes. I see that there is one question. Let me just take a look at it really quick. We received a full stop work order, then revised to allow some critical tasks to continue. The contractor asserts its right to the adjustment within 30 days after the end of the period of work. Does this assertion apply to partial lists? So if you received a full stop work and then a revised where they allowed partial performance, the lift of the stop work. So if from when they lifted that portion of work and they asked you to continue with performance, if you have stop work costs associated with just that portion, I would submit those as soon as you can, and I would clock it from when they revised the stop work order. And I would submit that REA based off of that, again, that small piece of work that I guess, that they had encouraged you to continue performance. And then once you get the rest of that stop work lifted, then I would submit an REA associated with those costs. So it would be really 2 submissions. And the reason why I'm saying that is you could probably do it together, but I think that you do create a risk for yourself under the stop work clause that because they lifted a portion of it, that clock has started to run. So the safest approach would be to submit an REA associated with the lifted portion. And then once the second piece gets lifted, to then submit a request for equitable adjustment tied to that portion of work. So I hope that makes sense. If you have any follow-up questions related to that, feel free to shoot me an email. But without any other questions, I hope that this was helpful to you all on this call. My information is there on the slide. My direct line is 202-857-1000. feel free to reach out if you have any questions, or shoot me an email. I'm happy to respond to any questions that you may have associated with stop work orders or terminations. And again, thank you so much for joining. I really appreciate it.